Imagine going to court for your immigration case. You're doing everything right, you're waiting for your date, you show up in court, and boom, you get arrested and put in detention. This is a new policy being implemented by the Trump administration right now. Immigrants are being detained at their court hearings and then getting deported. Why is this happening? Who is being affected? And what you need to know. Everything in this video. Hello everybody and welcome back to Immigration Channel. In this video, we'll talk about this new trend from the Trump administration to detain people who are going peacefully to their immigration court hearings, to continue their hearings, to get their cases processed, and boom, they get detained and deported. But it's very specific to a particular class of immigrants. I'm going to tell you who they are, who is being impacted, and if you're part of that group, what you can do to still protect yourself from being deported. So make sure you watch this video all the way until the end. So what's happening? About a month ago, we're looking at late April of 2025, immigration started implementing a new policy. And this is essentially the way it works. Immigrants show up for their court hearing. The judge then dismisses their case because remember, as long as you have a pending case, you're good to go. You're still in legal status and you can remain in the country for years. What the judge is doing is dismissing the case, working with ICE attorneys, and then as soon as the applicant comes out of the court, they're being detained by ICE agents outside. So why is this happening? Well, about a few months ago, the Trump administration started implementing policies for who can be expedited and removed from the United States. This is now specifically for people that came here in the past 2 years. So if you came here in the past 2 years and you don't have legal status, you are primarily target for expedited removal, which means you can be deported without a court hearing, without seeing a judge. Remember that you can either be here less than 2 years or you could have been apprehended within 100 miles of the border, then you were released into the United States. Again, your hearing will be dismissed and then you'll be placed in deportation. Now, people that were detained are of all ages, as young as 14, including full families that were going through proceedings like asylum together. Everybody getting detained. If you meet those criteria, meaning that you've been here less than 2 years, or you have certain convictions that will deem you deportable, those people will also get their cases dismissed and processed for expedited removal. Now, we've seen in some cases that even if the judge refused to dismiss the case, the applicant was still detained by ICE and attorneys are still trying to fight to get those people released. So remember, there's a lot of inconsistencies in many of the courts. And we're getting reports that people that even if the cases were not dismissed, in some cases were placed in removal proceedings. If this happened to you, let me know. There might be a way to help you as well. Now, how are the courts justifying these motions to dismiss? Like, why would they dismiss it now? Well, what they're doing, they're saying circumstances have changed. That's what they're using to dismiss those cases. So be mindful of that. This is very important information for you to be aware of. What the courts are using are saying circumstances have changed and now we need to dismiss this case. Now, when people ask you what exactly has changed, they don't say anything. They're using a boilerplate response to dismiss those cases because once they dismiss those cases, those applicants can be detained. Attorneys who are opposing those motions have 10 days to argue against dismissal. Now, denying these people the opportunity to oppose these motions is clear violation of due process. And it's happening all over the country. Like I said, this happened last week in San Diego, my city. At least 16 individuals got their cases dismissed. And right away after that, the attorneys didn't even have a chance to file a motion to oppose. They were taken into custody. Now, we have reports that other agencies are also involved in this enforcement. We've got agents from IRS, ATF, DEA agents are all involved in enforcement. Some people do have some minor criminal issues. Others don't. But these agencies all collaborate. So be mindful of that. Now, many of these officers are being spotted in courts all over the country. Some of them come in plain clothes, no badges, and use unmarked cars. So remember, guys, when you go to your hearings, make sure that you try to reschedule some of these hearings. Otherwise, your cases will be dismissed and many of you will be deported if you meet those criteria. Most things of these are happening right now. The following cities: Phoenix, San Francisco, San Diego, Miami, Orlando, Chicago, Kansas, Baltimore, Detroit, Las Vegas, Dallas, Charlotte, North Carolina, Cleveland, and Seattle. Those are the main cities we've seen enforcement happening right now. Who is going to be subject to this? If you came here without inspection and you've been here in the United States for less than 2 years, you're going to be a target. Number two, people that have their parole terminated are also going to be a target to this. A lot of people, like almost 400,000 people, lost their status last week. All of them are target for these kind of removals. And if you had any minor criminal record, the government could also use that to get your case dismissed and get you into expedited removal. So make sure you work with your attorneys to oppose this. Who is not subject to expedited removal? If you've been admitted and expected, you just overstayed, if you can prove that you've been here for more than 2 years, and if you're an unaccompanied minor under the age of 18, you're not subject to expedited removal. How can you protect yourself? Carry yourself document to prove 2-year presence. Photocopy of anything to show that you've been here for 2 years. Lease rental agreements, utility bill, bank statements, medical stuff, school records, anything that can show you've been here for more than 2 years. Mail postmarked for more than 2 years to your name. Now, if you're afraid to go back to your home country, you can still apply for credible fear interview and say to the government, I'm afraid to go back home, and they should not process your expedited removal. Now, guys, things are getting harder right now, and it's scary. I know that. But some of these things are happening, and it's important for you guys to be aware of what to do. If you have an upcoming hearing, you'll be aware that it could be dismissed and you'll be placed in removal proceedings. So make sure you follow the tips in this video to protect yourself. And if you need help with your immigration matter, send me a text 619-483-4549 or go to www.immigrationasap.com. Leave your details and one of our team members will help you and will contact you ASAP. Thanks for watching, and I'll see you on the next video. Stay safe out there, guys.